Let's talk about employment base and adjustment of status. Can I adjust status under EB1 or EB2 category, employment based self-sponsor? The answer is yes, you can, provided that you qualify for adjustment of status. When it comes to adjusting status under employment, the answer or the questions remain the same. Well, the question is this: how did you enter the US? With what type of visa? For the purpose, of this video, assuming that you enter the US with a B1/B2 visa, visitor visa, yes, you qualify, right, to adjust status. Then the second question becomes, are you within lawful status at the time of adjusting status? Basically, what type of non-immigrant status do you currently have? The other question is, did you maintain continuously lawful status at the time of adjusting status? Those are the questions that you have to ask yourself. And finally, are you really admissible? Do you have any criminal convictions, stuff like that? Those comes later on, right? But the main thing here for the purpose of this video again is lawful status. Did you maintain lawful status? Because when it comes to employment, well, if you have more than 6 months of unlawful presence, unfortunately, you cannot adjust status unless qualify under 245I, right? We already talked about 245I. Well, you can refer back to my previous video, but we want to do a case study on this subject because the question was asked yesterday: can I adjust status under EB2? I actually qualify under EB2 national interest waiver. I even have a sponsor who's really willing to sponsor me. Well, there's one thing to be qualified, right? Because you're gonna file the petition by using the form I-140, and if you really qualify, then the petition is gonna get approved. But the thing is, are you going to be able to get your green card? That's where it gets tricky, right? So then we ask the person, how did you get here? Well, the person says, I got here with B1/B2 visa, visitor visa. And how long have you been here? The person says, I've been living in the US for more than 10 years. Well, and what type of status do you currently have? The person says, I have TPS, so temporary lawful status. So I'm still within a lawful status. But then the other question, sub-question within those questions were, well, prior to you acquiring TPS, what type of status did you have in between? The person said that I did not have any status. I'm like, well, unfortunately, you cannot adjust status because you failed to maintain lawful presence. You get here around 2007, well, with a B1/B2 visa. Remember, it's only valid for 6 months, right? And then after 6 months, you didn't do anything. You didn't extend it. You didn't do anything. You didn't change status. You didn't do anything. So later on in 2011, you apply for TPS. Well, remember that you have like almost 4 years of gap, failing to maintain lawful status. Now that you're qualified under EB2, unfortunately, you will not be able to adjust status because you failed to maintain lawful status. So then we go to the exceptions, right? So do you qualify under 245I? Do you have any old petition, whether it's I-130 petition, family-based, employment-based petition, or labor certification that was filed in 2001, April 30th, 2001, that was approved or was approvable, at the time it was filed? So do you have any of those type of petition? Unfortunately, the person didn't have any. So pretty much you do not qualify under 245I, then the other question is, do you qualify under those technical reasons? For example, you failed to maintain status because it wasn't your fault. Those type of technical reasons fall under some different facts scenarios, right? For example, somebody, let's say the person comes here with a student visa, and then later on, prior to the student visa expiration, the person applies for asylum, and then the case is still pending with USCIS, then the person finds themselves qualified for EB2. At that point, it becomes debatable, right? The person can try to argue that, well, I failed to maintain lawful status because of technical reason, because my petition is still pending with USCIS. I filed my asylum petition while I was still within status, but unfortunately, USCIS hasn't responded to me yet. So for technical reason, I failed to maintain status, my lawful status. So now I believe that I qualify for adjustment of status, and that's a debate, right? Depending on what circuit your case will go, then depending on the reasoning and the facts and the argument itself, you might qualify for adjusting status under employment. Other than that, if you don't have those two exceptions, especially the first one, which is really good, 245I, if you don't have it, the second one is debatable, really, then unfortunately you cannot adjust status under employment. So the takeaway for this video is this, right? Failing to maintain status, failing to maintain continuous lawful status, not being within lawful status at the time of adjusting status, while unfortunately for employment base, if you have 6 months or more of unlawful presence, you cannot adjust status unless exceptions apply to you. Okay, that was it for today. If you need a consultation with me, you can schedule it on your own time by using the consultation link in the description box below. Also, please visit my community tab, because we have a webinar on motions to reopen. It's free, right? You can just register so that you can be sent the link, and then you can log in on April 7th, 5 p.m. Eastern time. I'll be there talking about motions to reopen. I hope to see you there. Okay, until next time, bye bye.